All rise. The Court of Appeal in the 4th and 5th District of the State of Florida is now in session. The Honorable F. Grant Walsh, Judge presiding. All persons having business before this court draw near, give attention, you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. Welcome to an oral argument session of the 5th District Court of Appeal. I've already been introduced. The other panel members that are joining me here today are to my right and your left, Judge Adrian Soud from Duval County, and to my left and your right, Judge Joe Boatwright from Putnam County. We have one case on the docket here, State of Florida versus Jean-Paul Yanez Blanco. And just before you get started, we just ask anybody in the courtroom, if you have any devices that may inadvertently make a noise, please put them on mute. Please power them down so we don't interrupt the lawyers when they're making their presentations. I'm going to assume, is it Mr. Schenk? Mr. Schenk, I'm going to assume, unless you tell me otherwise, 5 minutes of rebuttal?
3 minutes for rebuttal.
3 minutes? Yes, you may. And then, other than that, you may proceed when you're ready.
Good morning, Your Honors. My name is Robert Schenk for the state of Florida. The trial court here held that Mr. Yanez Blanco could not be prosecuted for his role in smuggling into this state over 24 individuals entering the country and who had recently crossed the border in Texas. The trial court believed that the process of entering the country, ceased at the border, such that even if you had a person going directly from Mexico, driving across the country into Florida, they could not and would not violate the statute.
Mr. Schenk, I don't know that it was specifically provided in the record, but was there a time frame that we have where approximately when the people crossed over the Texas-Mexico border to when they were discovered here on I-75 in Florida?
No, I don't have that specific time, although I will note in the record on page 27, there is a reference to the fact that these individuals, well, on pages 26 to 27, they had fresh scratches on them, and that the officers believed that they had been in the country only for a matter of at most a few days. And of course, on their way to Florida, they stopped at a gas station in Louisiana, and they have Mr. Yanez Blanco, I believe, had on his in his backpack a receipt from a gas station in Louisiana the prior night at the morning at 2:51 a.m. So obviously, I think this is happening in a very short period of time here.
So where did they enter the country?
In the U.S. border somewhere in Texas. We don't know the precise location.
So you know the path they took?
Well, it appears based on the brush marks that they would have entered somewhere in the desert where there's thick brush. But we don't have a precise location, Your Honor. But of course, I don't think that's, whether we know the precise location, I don't think that would prevent a jury from inferring that these individuals, under our test, had not reached their destination within the country before they reached the state of Florida. So I just want to turn to, first, the word entering in the statute. Critically, in its present progressive tense, typically we think of the word entering as meaning to pass into the interior of.
Is also important, correct? The
well,
phrase
yeah,
is entering?
Yes, I think that obviously all the context here is important, but of course in the present progressive tense of is entering, that's a continual action. It's not something that stops at one instantaneous moment in time. And so I think that supports our idea that the trial court's reading of the statute must be wrong, that it's just limited to border crossings.
How long can you enter, though? You say it's continual. Can that go on 3 months, 6 months, a year?
I think that's a fact-intensive question, Your Honor. I think that obviously the longer it goes on, I don't think there's a clear point at which it ends in time. And I don't think the statute contains that kind of strict temporal limit. But I think that the statute gives us some guidance to look to, and for juries to look to when they're trying to figure out, well, has a person reached their destination within the country?
Where do you get the concept of reaching their destination?
So
I know you give cases about arriving, but arriving is different than entering. I mean, the words are different, correct?
Well, there's two responses to that, Your Honor. They are different words. Yes, I agree. But even in the federal cases we give, the federal courts seem to use the terms arriving and entering synonymously, and I think that is generally how people think of those words. But the specific concept of a destination has textual support in the statute. It's drawn from the word smuggling, which is in the title of the statute, and that's a critical.
So you're not getting it from the definition of entering, you're getting it from somewhere else in the statute, is that correct?
A piece of context in the statute that informs the meaning of entering, right? So the smuggling case law that we've given you, that, even before the legislature passed the statute, there had been a long line of federal cases dealing with, sometimes they call it importation crimes, but either alien or drug smuggling. And those cases note that the smuggling is a transaction, right? It has a beginning point and an end point. And the end point for the transaction of smuggling is when the goods or the person reaches their destination. In fact,
Delivery.
Huh?
Delivery,
exactly. And that's what the 11th Circuit focused on in the United States v. Corbett case. It said that drug importation, which is another word for smuggling, is a continuous crime that is not complete until the controlled substance reaches its final destination point. So I think that context, which is expressly in the statute, right, it's part of the title that informs the meaning of these terms, focuses on a destination. I also want to point your honors to the broader phrase, right? We have not just is illegally entering the country, but that's bookended by is illegally entering the country, and you also have to have someone transported into the state. And we made this textual argument in the brief that the fact that the statute uses the from another country language is significant because no such similar limitation appears when we talk about transporting into the state. And entering this country always has happened from another country, right? So the natural way to read that is
Well, not necessarily. If it's overseas, if it's over a body of water, you're not coming in from another country.
Well, but the process of, entering the country, though, typically does, as a legal matter, right? This is a legal term of art drawn from federal law, does have to happen from another country. We gave an example in our brief of what they call voyages to nowhere, which is like when you take a cruise, you leave the port of Tampa, right? You go out and you circle around the Gulf of Mexico and you come back. Those individuals don't have to go through the process of going through customs and re-enter the country because under this legal fiction, they're deemed never to have left the country in the first place. So as a legal matter, I think in almost all cases, in order to enter the country, you do have to come from another country. And that's significant because it implies that transporting into the state doesn't have to happen directly from another country. It serves as almost like an expressio unius logic to highlight that transporting can happen into the state can happen from other places, like the state border with Georgia or Alabama. I also want to turn to...
So if that's your position, why did you use the language illegally entered in your information rather than is illegally entering?
Well,
I mean, you used the past tense, which is, I think, probably in the new statutory language. Is that just something STAC generates and the case management system spits that out? I'm just curious why you use that language rather than the is illegally entering that you're arguing here today.
So I actually don't know exactly why. I've had a few discussions with the state attorney here. I don't know precisely why they use that language, but I think it's just a very small part of the case. I think it's clear from the rest of the way that we litigated that we did believe that they were still entering at the time they were apprehended. I understand that there was that use of the past tense, but I just think that that's an oversight in the case. But I don't think that it's significant here because, of course, both the defendant and the trial court were on notice that what the state believed was happening was that they were entering when they were apprehended on I-75.
Can is entering be an instantaneous action? You can enter and then it's completed?
I think that that is, I don't think so, at least not in the context of this statute, Your Honor. I believe that based on all these contextual clues that we're taking into to give us meaning to the word entering, I just don't think that that's a fair approximation of what that term means here. I understand that the defendant in his brief.
Well, let's say it's both. Let's say you could say it's instantaneous. You could also argue it's continuous. Then are they correct then that the rule of lenity applies?
I don't think so, Your Honor. So I would point Your Honor specifically to the Connage case from the Florida Supreme Court in 2022, which we cited in our brief. The Connage case makes clear that the rule of lenity comes in, it's the end of the process, the end of the interpretive process. And the way that you're supposed to use lenity is you're supposed to ask, well, is there an ambiguity here? And specifically, the Florida Supreme Court said, when you're picking between two readings, if there's a better reading, then we're supposed to use that, and we're not supposed to apply the rule of lenity. It's where you have two plausible readings where you can't tell where one is better than the other. And I'll also note that the other reading has to be reasonable. And I don't think that the interpretation of this term that my friend on the other side has proffered is reasonable, because it would make the statute impossible to violate.
And why is that?
So under defendant's reading, right, and under our reading, entering has to happen while you're transporting someone into the state. They have to happen together. And if they're correct that entering is a process that ceases at the border, then it would be impossible to violate, because the U.S. and Florida borders are not coextensive, right? The U.S., even when we talk about the bodies of water surrounding the country, which is where the trial court and the defendant thinks that this statute is limited to, the U.S. has a further nautical border 12 miles out from the coastline in the United States, whereas Florida's border is smaller. So if it was true that entering only occurred at the border, I think it would be impossible to violate. But even if you could get past that,
And why is that again?
why
Why would it be impossible to?
So if entering ceased at the border, right? So you imagine someone's trying to come over to Florida by boat. They would cross through the U.S. border before they would reach Florida's nautical borders, and I believe in the Gulf of Mexico it's 9 miles, in the Atlantic it's 3 miles. So they cross the U.S. border. They've completed the process of entering the United States because they've crossed the border, but they haven't yet transported someone into the state. And because those actions aren't occurring at the same time, the statute couldn't be violated.
Why wouldn't it be remaining at that point? Once you cross the border and the status of the object of the transportation is still an illegal person, and so why wouldn't it then be the remaining in the jurisdiction as the crime?
Well, I don't think our statute doesn't use the term remaining.
Well, it doesn't anymore, but
Well, it never did. I don't believe they ever had the language remain in the statute. I think it may have been in a draft, but of course, I don't think, the fact that the legislature rejected a particular draft, I don't think is particularly helpful. There are a variety of reasons why a committee or the whole legislature would reject a specific language. I think we're supposed to look at, what was passed and how to interpret that language. But I'll take your point. I think that remaining itself kind of naturally implies that you've reached a point of destination, and then after you've reached that point of destination, then you're remaining. I don't think that, the second you cross the United States border, you're all of a sudden remaining. I think that there's some time between entering, I think there's some time where you start entering, you end entering, and then you're remaining in the country. And I think the destination point, again, provides a natural objective stopping point to that language. And I'd point, Your Honor, at least...
Well, but doesn't that also leave open to very subjective interpretation of the final destination? We're not talking about people that have, this is a vacation destination where they're going to arrive at one place. It's your argument leaves wide open a very subjective, non-objective interpretation of the facts of this case and ultimately the application of the law. Would you agree?
No, I wouldn't agree, Your Honor. I think it certainly presents a factual question, I think it prevents a question for the jury, and I think the jury decide these kinds of intent-based questions all the time. It's the kind of question that this court has said is particularly ill-suited to a motion to dismiss. But I don't think the fact that we're asking what was someone's intent while they're in this country, what is their destination, is necessarily any more subjective than routine questions of domicile or residence that courts answer and juries answer all the time. But I'd also note, Your Honor, that in just returning to the continuous nature of entering, I want to point Your Honor again to federal law, which in the context of entering, federal courts don't seem to treat entering as something that just occurs at the border. And you can see this in, there's a statute called, or a statute at 8 U.S.C. 1325B, and that essentially is a warrantless arrest authority.
You're talking about the one where she's arrested 25 miles from the border.
Right.
Is that correct? But I guess at what point does that kind of get a little ridiculous when you're talking about from the Texas border, now you're saying they've gone through Louisiana, now we catch them in Hernando County. I mean, like, again, it goes back to my original question. At what point does that entering stop? I mean, they start working their way up the East Coast. I mean, end up in Maine. I mean, I'm asking if you can explain.
Sure. If
you can address that.
Yeah, no, and I understand that there's a concern about focusing on when that destination has been reached. I think that we should, and this court should eschew any language based on strict temporal or location-based limits. I think, again, the smuggling case law comes in to help the court by giving it a natural bookend, focusing on where this person's destination is. So if they were to say, well, their immediate destination is in Texas and they stay there for a year to make up money, and maybe they have plans to one day move to the state of Florida in the distant future, and they just need to make money in the meantime, and they're working there and they built a life there, I think most, if not all, juries would conclude that no, they found a destination in Texas, they reached that destination, and the fact that they later go to the state of Florida is, or they go to visit Florida on vacation after they've been here for a year, I just don't think that it's that would be a reasonable application of the statute, and especially since the statute has now been amended, there's no.
So should we take anything into account as to the statute being amended that this one was poorly drafted?
Well, I certainly don't want to ascribe to the legislature that it had poor drafting in creating this statute.
That happens, doesn't it?
Well, certainly. I mean, yes.
Okay.
I'm not going to ignore reality that sometimes, that things are drafted in certain ways that are overlooked or are part of a compromise. But I think actually here, I don't think it's necessarily poorly drafted. In enacting this statute, Your Honor, the Florida legislature was trying to carefully tailor a piece of legislation to address a specific problem. The primary concern they were having is just how do we deter the influx of illegal immigration and of individuals coming to this country, or coming into this country specifically for the purpose of coming to
The new statute, though, you would agree, has cured the argument that we're having here today, correct?
Yes. Yeah, I agree. As we've, and that statute has currently the subject of federal litigation in the Southern District of Florida in a case called Farm Workers Association. I believe it's now, it used to be versus DeSantis. Now it's Moody because the governor has been dismissed. But yes, so that statute certainly broadens an already broad limitation on the ability of individuals to smuggle in the state. But I do want to say that...
I just want to let you know you're in your rebuttal time.
Oh, okay. I understand, Your Honor. I just want to wrap up briefly. I just want to make sure that I say that this is a narrow piece of legislation where they're focusing on individuals who had recently come into the country. They're trying to deter that. And then they did broaden it. But I don't think the legislature should be punished. Instead, it should be lauded for writing a narrowly tailored piece of legislation as it did in the prior. Now, they have expanded it, and they have the right to do that. But I would ask for all those reasons that you reverse the trial court and reinstate the information. Thank you, Your Honors.
Good morning, Your Honors.
Good morning.
May it please the court, counsel Victoria Cordero on behalf of Mr. John Paul Yanis Blanco. This court should affirm the dismissal of the human smuggling charges. Appellant is challenging the interpretation of the statute that was in effect in 2022, specifically, is illegally entering the United States. The conduct at issue from Mr. Yanis Blanco's standpoint, this was an occurrence in April of 22, and as appellant discussed, there were individuals that were already in the United States. They were some of them staying at a stash house. They were already here. They had crossed the border when
Ms.
Mr.
Cordero,
Yanis...
before you get too far down the road, could you answer the question that Judge Boatwright posed as far as the current version of the law that we're talking about right now? If the current version were in effect, it would alleviate any discussion that we're having here today. Would
Yes,
you
Your
agree?
Honor. And to be quite frank, the conduct that Mr. Yanis Blanco displayed back in 2022, today he could be prosecuted, to be quite blunt. But at the time, because these individuals were already in the United States, when he provided transportation from Texas into Florida, he cannot be prosecuted under that statute.
Can you address the state's argument, and you're talking about these individuals had already entered the United States, but it's not the individuals who are being prosecuted here, it's Mr. Yanis Blanco for smuggling.
Correct.
So the statute's focus seems to be on smuggling. So why is that not an ongoing process, as he argues, as the state argues in this case, and that when he got caught in Florida, the statute wouldn't apply?
Yes, Your Honor. We do have to look at the plain meaning of the language, looking at the supremacy of the text principle. The words governing the text are of paramount concern, and what they convey in their context is what the text means. Enter, to look at the plain meaning, means to go or to come in. Although entering is a present progressive term, as the appellant pointed out, it concluded. The actual verb to enter concluded when these individuals crossed the United States border. Because of that reason, of the fact that there was a conclusion of the act, the conduct, Mr. Yanis Blanco cannot be penalized for something that already occurred.
So, Ms. Cordero, if I assume this hypothetical that the vehicle with its occupants enter the United States over the Texas-Mexico border, and then in less than 36 hours they are present in the state of Florida. So rapid transportation from Texas to the state of Florida, quite honestly, I would not want to be on I-10 if somebody was that rapidly coming to the state of Florida. But in that very abbreviated span of time, your argument is no crime here based upon the reading of the statute that we have before us.
Correct, because is illegally entering, the verb was concluded, the action was concluded. Although they may have been in the United States, they could have come into the United States that morning. We don't know when, however, they did come into the United States relatively recent, when Mr. Yanis Blanco did provide transportation from the undisputed
Well, if your
material
client
facts.
is bringing them across into the state of Florida, transporting them, as the state argues, how was that crime committed when they came across the border? I'm just trying to figure out why, if it's smuggling, why the language that you're referencing is so important in this case.
Could you repeat your question, Your Honor?
Sure. Why when they came across the border, why does that necessarily matter when what we're really talking about is Mr. Yanis Blanco bringing or smuggling individuals into the state? Why does it matter when they came in or where they, as long as they came into the United States illegally?
Yes, Your Honor, because the statute in effect, a person who brings into this state an individual who they know or should know is illegally entering the United States from another country at that time. We do have to look at these individuals, and if they were illegally entering at the time they were brought, transported by Mr. Yanis Blanco.
So you're saying they have to catch them in the act at the border? Is that the argument?
I would argue, Your Honor, that Mr. Yanis Blanco would have had to transport these individuals from Mexico over the border and into Florida, because at the time when he brought them from Texas to Florida, they were, in fact, already in the United States. So the process of is illegally entering, that had already concluded. Just looking at the plain meaning of the term enter, which means to come in, to go in, and that's just a dictionary definition.
So is there any scenario in which any individual could ever be prosecuted under this statute for smuggling an illegal alien who enters in Texas?
I
It would be logically impossible, would it not?
It could be quite difficult to prosecute someone under the
It would
old
be
statute.
impossible.
I believe
I
it
mean,
could be.
if we take your reading of the statute, it would be impossible for this statute to be a basis for prosecution for smuggling an illegal alien into this state if they enter through any other border except that of the state of Florida, even if we were to overlook the territorial waters argument from the state. You agree with that?
Yes, Your Honor, I would agree.
So if, and I don't mean to cut you off, and I'm gonna let you argue in just a moment, but if we were to, of course, and I think you rightly talk about textualism, and we are to afford the supremacy of the text principle and what the words say, or, you know, what the words mean is what the statute says. What is our end objective in applying the supremacy of the text principle?
We need to look, yes, Your Honor, we need to look at just what these words actually mean. And as the state did point out, entering does indicate a current action. However, to look at the verb itself would show us that this verb concluded.
Well,
And
this is a present progressive tense, and I don't mean to become a grammatical zealot, but grammar is a permissible indication of meaning. You agree with that?
Yes, Your Honor.
And so, beyond grammatical zeal, if we were to look at the statute, is it not relevant to us that is included in the statement, is illegally entering? It's not entered. It's not a past tense verb. It's a participle.
Yes, Your Honor, you are, yes, you are correct. With the ing, we have a present progressive, which would indicate that this action is currently occurring. However, looking again just at the plain meaning of the verb, there's no way to have this verb continue. It's an instantaneous event. It's not like arrive, which was used interchangeably by the appellant, and they have different meanings. Arrive means that you're reaching a destination, you're coming to an end of a journey. It's not an instantaneous event like enter, and that's where there was some confusion, I believe, and that it's inaccurately applied, that here in this instance we have to look at the verb enter, and that you can only enter, you can only cross the border in this instance once. So once these individuals crossed over the border and were already in Texas, that had concluded, that action concluded.
So to that point then, if we were to accept your interpretation, and if your interpretation renders it impossible for an individual to be charged for smuggling an illegal alien into this state, if that illegal alien entered in another jurisdiction or another portion of the United States other than Florida, is that a reasonable reading of this statute?
It may not be the best reading of the statute, Your Honor. However, it was amended. The legislator probably saw the problem that it posed and did rectify it by changing the verb tense to the past tense, has entered.
So let me go back to my question initially. Is that a reasonable, you said it may not be the best reading. Is it a reasonable reading? Is your suggested interpretation a reasonable reading of the language of this statute?
Yes, Your Honor, because we cannot...
Go ahead, I'm sorry.
I was just going to say, we cannot punish individuals who, such as Mr. Yanis Blanco, found themselves in such position where they were transporting individuals. And to be quite blunt, he probably did know that these individuals were undocumented individuals that had recently crossed the Mexico border.
Well, I mean, he himself had no driver's license.
Correct, Your Honor. Correct.
Right? I mean, and he had 20 people in the back of a 350 van so heavy that it was overloaded and weighing down in the back, according to the trooper, right?
Yes, Your Honor, and these were the undisputed material facts presented in the C4 motion, and we are not challenging that. We accept those facts and the fact that, again, he probably did know that these individuals were undocumented. However, relying on the old statute and the use of is illegally entering, we cannot be prosecuting individuals such as Mr. Yanis Blanco because his actions were not criminal. However, under the current statute, he would have more problems. He could face prosecution. And so looking at the actual plain meaning of these words, enter, this is just very important, again, to show that the conduct has concluded. To apply the state's theory where is illegally entering is a continuous action, that doesn't conclude until the individual reaches a final destination. These undocumented individuals could be necessarily traveling forever. They may not reach their final destination for days, weeks, months, years. Who are we to say that they even have a final destination because their goal could be just to enter the United States?
Is whether somebody is in the process of entering, if we were to accept the interpretation from the state, and is it ultimately a jury question as to whether or not somebody is still in the process of entering the United States?
It could be, Your Honor, it could be.
So let me ask you this. Your argument, if I heard you correctly, is once they have landed both feet in the United States, their entering is concluded. Is that right?
Correct, based on the definition of enter.
What if they crossed over into Texas, they encounter Border Patrol, and they start running, right? And in the process of running, they meet with a smuggler who gets in a van and transports. Would that still be in the process of entering?
I would say it has concluded. They are already on Texas ground. They have entered the United States, so that action has concluded.
Okay.
And
Can you
again,
address the state's argument that under your theory of how this, or under your interpretation of the statute, that the statute cannot even be prosecuted in Florida? Do you think that's correct? Can the statute be prosecuted in Florida, or can this be prosecuted in Florida under the statute as it stands?
are you
I
referring
mean, his argument was individuals are already reaching into Florida waters 12 miles out, so if they got picked up, let's say in Miami on the beach, that they could not be prosecuted using or relying on your interpretation of the statute.
I believe they could still be prosecuted. I know the trial judge did reference or provide an example of someone who flew in, for example, Cuba, and had in the
They still have to fly over that area, though, correct?
Correct. They would fly from that international country and then come and land in Florida, the state of Florida, and they perhaps had narcotics and in addition had undocumented individuals. That individual could possibly be prosecuted.
So what if, in that scenario, they make their way all the way up to Hernando County, like in this case? Do you think they could be prosecuted under the statute at that point? Or do they have to be, or does the crime have to take place in Miami?
I would believe the crime would have to take place in Miami. That's where they did enter from the country into the state of Florida. And again, looking at the fact that following this continuous act where the undocumented individual doesn't...
To kind of go after Judge Soud's questioning to you, I mean, how is that, are there other, I mean, you're almost saying they have to be caught in the act. I mean, can you name another crime where you have to be caught in the act?
I could clarify, Your Honor, that, for example, if Mr. Yanez Blanco had brought these individuals from Mexico into Texas and then proceeded to bring them from Texas to Florida, perhaps then he could have been prosecuted.
You're saying because he personally didn't bring them across the border, that's why you don't believe this statute applies to him?
Correct, and also for the reason that these individuals had already entered the United States. The action verb, the conduct had already concluded. They were here within the United States.
The subject of the criminal conduct contemplated in Section 787.071 is the smuggler, not the illegal alien. You agree with that?
Yes, Your Honor.
Is that relevant to the court's analysis?
Yes, Your Honor, because again, Mr. Yanez Blanco or anyone in his position, they're facing criminal charges, they're facing prison time. We have to look at what they did in this instance and the fact that what he did here by bringing these individuals from Texas to Florida, that's not criminal. Under the new statute where it has entered, he could be facing serious problems. However, based on the old statute, is illegally entering, these individuals already had entered the United States. Again, although they may have entered, for example, that morning, in this case, it doesn't matter because Mr. Yanez Blanco provided them a ride from Texas to Florida, and they were stopped in Hernando County because, as Your Honor had mentioned, the traffic stop. No doubt about that, there was a traffic stop. However, he cannot be he cannot be punished under the old statute, and it has been amended to rectify that situation. If the statute...
So just so I'm clear of your argument, the clarification is, if Mr. Yanez Blanco had taken them from Mexico across the border, then drove them to Hernando County, you say potentially he could be prosecuted for that. The distinction you're making is that he did not take them across the border, thus the statute does not apply to him. Is that what I'm hearing?
In part, Your Honor, yes, that is partially true. However, the main concern is that these individuals had already entered the United States. They were not in the process of entering. They were already here in Texas when he went to Texas, or he was already in Texas and provided them a ride from Texas to Florida.
So even if he helped them cross the border, once they're 2 feet or on the soil of the United States of America, he can no longer be charged under this statute because A, it's Texas, but their entry is concluded, his smuggling is concluded once they've entered under the language as it existed at the time, and anything that takes place after that, he could not be charged with.
I can't speak to that, or unless I misunderstood. Could you repeat yourself, Your Honor?
Sure. So, in other words, if he were involved in smuggling of illegal aliens over the border in Texas, once they have arrived and entered, if we accept your interpretation, his smuggling that is chargeable under the statute is concluded because their entry is concluded.
Correct.
Am I misunderstanding your argument?
No, Your Honor, unless there's another statute that would criminalize his actions in providing assistance with these individuals crossing the border regarding the specific 78707 subsection 1 statute, he could not be criminalized, or he could not be punished. If the statute was deemed to be ambiguous, then the rule of lenity would need to be applied and construed in my client's favor, which was done below.
This statute contemplates more than one factual occurrence. Does that render it ambiguous?
Could you repeat?
If the statute contemplates conduct of 2 different kinds, each of which would constitute a crime under the language, does that render the statute ambiguous?
No, Your Honor, because we need to focus on the entering portion. This is the part that has caused quite a confusion or quite a difficult interpretation, and entering can only be interpreted one way. Someone has come in or gone into an area, and that has concluded, that verb has concluded. But if there was deemed any sort of ambiguity, then we would have to rely again on the rule of lenity, and it would have to be construed in Mr. Yanis Blanco's favor. Under the proper interpretation of the statutory language, the undisputed facts do not establish a prima facie case of guilt against Mr. Yanis Blanco, where again, he drove these individuals who were already in the United States, and he drove them from Texas to Florida, and he is not guilty of 78707 subsection 701, excuse me. And if the court has no other questions, I will rest on my brief and ask that this court affirms.
Thank you. You have a little over 2 minutes.
I just have 2 things to touch on. First, today and in their brief, the defendant has not addressed any pieces of critical context that I put forth today. They rely solely on the one dictionary definition of the term enter. But I also want to note that the defendant and his counsel here today has said that the statute may be violated if this person drove a person directly from Mexico. But if he had a white E350 van gassed up on the other side of the border, that couldn't be a crime under the statute. And I agree that we look to the supremacy of the text principle, Your Honors, but that requires us to look at all of the context in the statute, and it requires us to make common sense of the language that the legislature passed. And that just doesn't make common sense.
We're to read it reasonably.
Yeah, absolutely. That's even though we rely on all these technical tools of statutory interpretation, they're just tools. They're just tools for us to help reach a reasonable interpretation of the language. And I think that our interpretation is the best and only reasonable interpretation that's been put forward for the court. Again, if her other definition provided, the border crossing definition, is correct, then I don't see how.
Doesn't that make, when you talk about reasonable interpretation, I agree, and I agree with Judge Soud, that's what we're supposed to do. But when you talk about a criminal statute, isn't there a part of that we are strictly construing that in favor of the defendant?
Well, I think I think
in a context like this?
I think the right thing to do is construe it fairly, but I think the rule of lenity provides us help if there is a genuine ambiguity. We do construe that strictly against the state. But again, as the Florida Supreme Court said in Connage, where there's a better view, we don't apply the rule of lenity, right? We have to have 2 equally weighted, the court there said that 2 interpretations, even if they were a draw, then it would apply the rule of lenity. But that's not the case that we have here. And may I briefly conclude?
You may.
Yeah, thank you. I also just want to note that I don't think that just by expanding the scope of the statute in 2023 that the legislature was trying to correct any defect. They were just broadening the effect. But for all those reasons, Your Honor, I would ask that you reverse the trial court's dismissal and remand for further proceedings. Thank you.
Thank you. Thank you, counsel. Case was well argued, and we will be in recess.
All rise.